The principle of latam mortem, which means words said before death, and in a legal term it is called dying declaration. Section 32 subclause 1 of Indian Evidence Act defines that when a statement is made by a person about his cause of death or of the circumstances which resulted his loss of life in cases in which the cause of person's death comes into question. Such statements made by the person are relevant. Dying declaration is treated as evidence and admissible in a court of law. There is a particular form of dying declaration. It can be oral, written, gesture and signs, thumb impression, incomplete form, and can also be in the form of question and answer. However, there must be a distinct and definite assertion on the part of the person who produces the statement. Possibly, the declaration should be in written form in the exact words stated by the person who made that statement. When a magistrate records the dying declaration, then it should be in question answer form, as the magistrate will opt the maximum information rightly. As in some cases, dying declaration becomes the sole way to help in the conviction of the accused. So let's discuss some of the types in the elaborated form. First, gesture and signs. In case of Queen Empress versus Abdullah, the appellant was charged with the offense of murder before the court of session, that he had murdered Dulari, a prostitute, by cutting her throat through razor. It seems that one morning Dulari with a throat cut was taken to the police station and from there to the dispensary. She was alive till morning. When Dulari was taken to the police station, she was questioned by her mother in front of a sub-inspector. She was again questioned by a sub-inspector and then deputy magistrate and subsequently by a assistant surgeon. She was unable to speak but conscious and able to make gestures and signs. Magistrate asked Dulari as who had wounded her, but due to the injured condition, Dulari was unable to speak. After that, the magistrate mentioned several names one by one, asked if they had wounded her. Dulari moves her hand forward and backward and made negative and affirmative signs. Subsequently, the magistrate asked whether Abdullah had wounded her. For that, Dulari waved her hand and made a sign in the affirmative. The magistrate recorded the statement. After that, question was put to her that if she had been wounded with a knife or sword. In this regard, Dulari makes a negative sign. Again, magistrate asked her if she had been wounded with a razor. She, in answer to this, made an affirmative sign. In this way, magistrate records the dying declaration of Dulari, and same was accepted as evidence to prosecute Abdullah. Similarly, in recent year, Nirbhaya rape case, dying declaration was made by her in the form of sign and gesture. When a person gives the name of the murderer to a person present and written by any of them, then it is a relevant dying declaration. However, people may dispose of the name of the murderer orally. An oral dying declaration is admissible in evidence as an exception to the general rule of evidence that hereby evidence is no evidence in eyes of law. In case of Amar Singh versus State of Rajasthan held that the statement which made by the deceased person in which deceased has written her cause of death shall be admissible if such statement has some proximate effect. Dying declaration made by the person which is incomplete cannot be admissible as evidence. It was held that the dying declaration is not admissible in court as the declaration appears to be incomplete, but the statement through it is incomplete in the sense but conveys by the declarant all necessary information or what he wanted to state but stated as complete in respect of certain fact, then the statement would not be excluded on the ground of its being incomplete. Dying declaration can be made in the form of question-answer. When the magistrate records the dying declaration, it must be preferred to be recorded in the form of question-answer. Supreme Court of India in concern to multiple dying declarations, it can be considered upon without corroboration if there is no breakdown of fact in all the dying declaration. If all the dying declarations are similar to each other and state correctly the cause of death and there is no contradiction between the statements, it can be admissible. But if the dying declaration is different from each other and there is a contradiction between them, then court will cross-examine the facts of the case or can examine the statements of other witnesses to determine the truth and sanctity of the statement regarding the case. In a situation where a person dies after when a FIR was lodged and stating that his life was in danger, it is relevant to be recorded as circumstantial dying declaration. It was also observed by the court that dying declaration must not show the whole incident or narrate the case history. Corroboration is not necessary in this situation. Dying declaration can be declared as the exclusive evidence for the purpose of conviction. When the dying declaration given by the deceased is recorded, but the question arises that after the dying declaration was recorded and the deceased is still alive, was the statement holds the same effect? In that situation, the deceased now turned to be a witness against the accused to narrate what the actual story was. As the dying declaration itself mentioned the word dying, so it is necessary that there must be an expectation of death on the part of the declarant. At the time of giving a declaration, the person who's making the statement must be in a fit state of mind. If the court has slightest doubt about the mental soundness of a maker of dying declaration, it is unsafe and unfair for the base on such a statement. Any person can record the dying declaration made by the deceased, but the person who is recording the dying declaration must have some nexus with the deceased, either circumstantially or by some facts. However, the doctor or police officer hold more value as compared to the normal person. As far as dying declaration is concerned, the magistrate entrusted to record the dying declaration. Where the judicial magistrate or police officer or doctor is not available, the court cannot reject the dying declaration solely made before the normal person. But the person who records the statement must show that the deceased was in a fit state of mind and conscious while making the statement. If there is no time to call the magistrate, keeping in mind the deteriorated condition of the declarant, the statement can be recorded by the doctor or by police officer. But one condition must be coupled with it, that while recording the statement there shall be one or two persons present there as a witness. When deceased statement recorded by the competent magistrate has deemed to be considered as a reliable and attracts the evidentiary value, as he presumed to know how to dying declaration should be recorded and he is natural person. Moreover, the magistrate has empowered to record the dying declaration under 164 of CRPC. So that's all my friend, hope you like the video, and if you do then please like and subscribe my channel. It will encourage me to make more videos like this.